Good morning. I'm Jessie Gilbert from the Greenwich office. I've been tasked with talking about a major change in the Connecticut law, which is the Connecticut Uniform Trust Code. Now, the good news is, in most cases, this isn't going to change how trusts operate, but there are a number of places where there's some big changes, and I'm going to review the provisions where there are big changes. In general, new trust code is going to apply to both testamentary and inter vivos trusts, but it will not apply to charitable trusts or certain business trusts. It provides certain rules that are going to apply if the trust agreement specifically doesn't have them. And I'm not going to go into these things in specific detail. And again, most of them don't change existing law. I'm not going to read them, but there are a few that have major substantive changes in how trusts operate in Connecticut. I'm also not going to, as you can see, read my slides. These slides are here for reference for you later as backup for the things I'm going to talk about. I want to make sure I have enough time to go over certain things. First of all, the testamentary trust rules really have the CUTC has the least impact on those. Just a brief reminder of the difference between the two. In general, testamentary trusts are trusts that are created under a will document. It's as simple as that. And if that happens, then the trust is subject to probate court jurisdiction. An inter vivos trust is a trust created under a separate trust document. An inter vivos trust can be revocable, like living trusts, or irrevocable for a gift trust. Testamentary trusts are still subject to probate court supervision. I'm not going to go in detail over jurisdiction issues in that regard, other than to say that the Connecticut Uniform Trust Code significantly expands probate court jurisdiction over inter vivos trusts. That doesn't mean that the court's going to supervise those trusts, but what it does allow trustees to access the probate court to rule on various things. Before, we had to sort of shoehorn, if we wanted the probate court's input on a inter vivos trust, we'd sort of have to shoehorn our jurisdiction by bringing an accounting procedure or certain other procedures. Now the rules are greatly expanded, and you don't have to go through those machinations. Now here's the biggie. This is the big change. Before the Connecticut Uniform Trust Code, Connecticut trusts could effectively, inter vivos trusts effectively could be silent. So taking it back in context, testamentary trusts, as you know, the trustees have to file inventories with the probate court. They have to file accountings. They might not have to file periodic accountings, but eventually, when the trust ends, they have to file a lot of financial information with the probate court and provide that information to the beneficiaries, copies of the document, financial information. That was not the case for inter vivos trusts. So trustees could manage and operate trusts, and settlors our clients could set up trusts that the beneficiaries wouldn't necessarily have to know about. And even if they knew about it, they weren't required to get financial information. And that's a big reason why many clients set up their estate plans with inter vivos, revocable, or gift trust structures so that they could take advantage of this ability to operate in quiet without disclosure. That is different now. Now, inter vivos trusts, trustees of inter vivos trusts are required to give information to beneficiaries. They need to give the copy of the trust. They need to tell the beneficiary what's in the trust. And every year they need to account to that beneficiary and provide all the beneficiaries, so existence of trust, financial information, and annual reports to the beneficiary. So how do we address this? Because this is majorly different from what we've been doing before. First of all, you could have the beneficiary waive their right to get this information, but you're going to have to at least tell the beneficiary and give them the information that they're going to waive going forward, and that might be problematic. So the important thing for any trusts starting in January 1 is to have a mechanism called a designated representative. And what this does is allow the trustees to provide this information instead of the beneficiaries to this person called a designated representative. The important thing of this is that person can release the trustees of their obligation on behalf of the beneficiaries. The most important thing about this is that you need to build this into the document. It has to set out what is the mechanism for naming the designated representative and who is that going to be. Because if you don't have that, then the trustees are going to have that disclosure requirement. So, important thing are the effective dates. So, this rule does not apply to irrevocable trusts already in place. They are grandfathered in. Anything that was signed before January 1, 2020, irrevocable trusts, this doesn't apply to. It does apply to all irrevocable trusts starting on January 1. For revocable trusts, living trusts, it doesn't apply now, but it will apply. Even if the revocable trust was signed before January 1, if it becomes irrevocable after January 1, in other words, if your client passes away after that time, then these rules are going to apply. So I urge all of you as advisors to reach out to your clients, or when you see your clients, to take an inventory of what they have, if you think this rule is going to apply, and if it's important to your client to have a silent trust, then the designated representative mechanism needs to be added to their documents. The law now allows for very different approaches to documents. There's now a much wider ability to change or modify the terms of the trust. So people interested in an agreement can go to court to change provisions of the trust if it doesn't violate a material purpose of the trust. They could go to a court to get information or agree about interpreting the trust or certain trustee authorities, getting trustees in and out, even changing of situs, for example. Though under this particular section 11, it can't be used, this section can't be used to modify or terminate. But that's governed by a whole other sections. So I'm just going to run through them. Section 30 and its associated sections now permit trusts to be terminated under certain circumstances. For trusts created after January 1, a court can modify a trust agreement, even if it's inconsistent with the trust's material purpose. And this section sets out who would need to consent in those circumstances. Section 32 allows the dispositive provisions of the trust to change if there were circumstances not anticipated by the settlor. Or Section 35 allows a trust to be terminated if it's too small or not serving its purpose anymore. Section 36, a court's allowed to reform a noncharitable trust to conform to a settlor's intention if it's proven that the trust is not, there was a mistake in fact or law when the settlor set it up. Section 37, a court can modify a trust to achieve the settlor's tax objectives and make the modification retroactive. Section 38, trustees can merge trusts or split them up. So a lot of new stuff, and we're going to still have to kind of feel our way through this because this is very new for our state. But for all of them, I just want to caution, just because the law says you can doesn't mean you should. You have to consider very carefully what are the ramifications. There could be income tax impact. Is the changing of the trust going to accelerate on any unrealized income items or gain or loss in the trust agreement? Will the changes remove the possible GST grandfathering? Will that be lost if you change the trust? Or will that have an impact on the GST exemption? Don't know. We need to be careful. Another big change. So, we have always counseled clients if they want to provide maximum creditor protection for their beneficiaries, that the trustee should be granted very broad ability to distribute income and principal without any standards. So, by way of review, standards, HEM standards, health, education, maintenance, and support. And what those are traditionally or formally, if you put these into a trust document, there would be less creditor protection. Now, I know it sounds counterintuitive because you're like, well, the beneficiary is going to want that, and isn't the money actually going to be used for those purposes? But the issue is often like the word support. So, for example, if I'm going through a divorce and the trust is for my support, well, guess what? I have a legal duty of support for my spouse or soon-to-be ex-spouse, and he could theoretically enforce my support, my ability to get support, and he could enforce it against the trust and get access that way. So that's why we always say broad standards. This law changes things completely. It says that even if you have these ascertainable standards, the health, education, maintenance, and support standards, there's still creditor protection. It says if the beneficiary has a 5 and 5 power, the ability to withdraw the greater of $5,000 or 5% of the trust, that doesn't cause creditor issues for the beneficiary, even if they have a crummy withdrawal right. So, interesting. I would not feel comfortable counseling my client to rely on those provisions until the law has developed more and we understand exactly how that will apply here in Connecticut. If I have a client who wants complete asset protection for their beneficiaries, I'm going to have broad standards of distribution. Another big change is in the grantor trust tax rules. So, as you probably remember, a grantor trust is a trust that is basically invisible for income tax purposes. So a grantor typically will set up an irrevocable trust, and because of the way it's structured, all the items of income, gain, loss, etc. are reported by the grantor on his or her individual income tax return. And that can be a really great setup, right? Because essentially the irrevocable trust is getting all these income items tax-free. The grantor is paying the income taxes, they're reducing their estate, and the payment of those income taxes is not considered a gift. That's a great situation. But for some clients, enough is enough, right? So they might have a cash flow issue and don't want to pay the income taxes on the trust anymore, or they just don't want to. They think they've given enough. And wouldn't it be nice if they could just get reimbursed for the income taxes they pay or have the trust pay those? And in Connecticut, we didn't have any mechanism for doing that. The fear was that if the trust paid the grantor's income tax liability, that would be some sort of retained interest or benefit on the part of the grantor. And if it was considered that, then it would be possible, theoretically, that the IRS could say, well, there wasn't a completed gift, or even if there was, when the grantor dies, that was some sort of retained interest. And so we didn't do it. Now, But New York and now Connecticut have a law that specifically says it's okay. It's okay for a trust to reimburse or take care of the grantor's tax authority. And now this will give us a lot more flexibility and confidence in adding that sort of provision into trust documents. Those of you who are professional trustees or work for professional trustees, there has been a change or clarification of the conflict of interest laws. You will be glad to know that now if as long as the trustee is investing the investments in accordance with the UPIA, it is okay to invest in your own funds and insurance and use your own traders. And now we lawyers are going to be really glad because hopefully you won't ask us to add those 5 pages of waiver of conflict of interest rules into our documents. Now well, I know you still will. But anyway, but at least the law now backs you up on that. There's also been a refinement in the trustee compensation rules. Under general Connecticut law, all fiduciaries are governed by the case of Hayward v. Plant, which says that compensation must be reasonable. Now, this statute says that if the trust document says that the trustee shall be paid in accordance with its usual fees, its standard compensation, and if the terms of the trust agree to that, then that's okay. It's not going to be subject to the Hayward v. Plant, the reasonableness standard. It is still subject to review by the court, but what the court is going to do is review to say, for this agreed upon fee, did the trustee actually perform what was contemplated in accordance with that agreement? So the important thing about this is that it gets set out in the trust document. Finally, we lawyers are so happy to have all of you because when we act as trustees, we don't want to be investing any trust assets. We don't know how to do that. We want to delegate it to people who know what they're doing, and this section lets us do that. And so we thank all of you for taking care of that for us.